Hi, this is Rob Carolina, and this talk is about challenges of incorporating cybersecurity law and regulation into higher education and professional qualification systems. For those of you who haven't met me, I'm a lawyer, and I've spent my career specializing in how the law is applied to information and communications technologies. Now, for a long time, I've spent teaching an MSc degree module on legal and regulatory aspects of cybersecurity, and the focus of that module has evolved and changed over the past few decades. I'm also the author of SCIBOC, the knowledge area on law and regulation. Now, to get the talk started, I suppose what I should do, if many of you are asking, remind me again, what is SCIBOC? Okay, fair enough. Let me explain. SCIBOC, the Cybersecurity Body of Knowledge, is a large project that was commissioned by the government of the United Kingdom. It's essentially a gift to the world. It's available for free on a very open source style license. The document in total is more than 850 pages, and it includes 5 subject matter areas that the editorial board and their very large advisory board felt represented the types of things that cybersecurity practitioners need to know. Those then become 19 sub-areas, and I wrote one of them to do with law and regulation, including ethics, that matter to cybersecurity. The authors of this work are all around the world, in Europe, North America, UK, all kinds of places. But I'm only going to be talking about law and regulation in this talk. So the law and regulation knowledge area of SCIBOC is about 112 pages, a lot of sources, additional notes, etc. Again, downloadable for free, and it subdivides into 15 sections, an introductory section plus 14 numbered sections. The actual contents list is right here. So I have recorded a completely separate and pretty long webinar that introduces what this subject matter is about. And I'll try to link to it in this recording so you can find it easily. My recommendation for those of you who are new to the subject is to read the introduction and then sections 1 and 2 on introductory principles of law and jurisdiction. I think those are foundational to understand anything else that follows. Obviously, section 13 on ethics is incredibly important, as is legal risk management. I'll talk a bit more about some of these subjects as we get a bit more into the talk. Well, after I wrote this work, I started to wonder a couple of things. I wondered, how will degree program designers, people who are actually trying to incorporate SCIBOC and related cybersecurity material into their curriculum, how will they know which law and regulation subjects are more or less important for their program? How will they figure out how to assess proposals to cover gaps in their ability to deliver material? How will they adapt legal curricula for a multinational student body? So I also wondered, how will students choose from a large variety of legal and regulatory topics to study in support of their career goals? And for that matter, I began to wonder, how will professional bodies choose from this very wide array of legal issues when deciding on accreditation standards? And last but not least, I also wondered, how are people who are going to teach this stuff, how are they going to deliver it in a manner that's relevant and accessible to cybersecurity students? So those are the sorts of things I was wondering, and that's what led to this talk. Let's begin here. Basic challenges when attempting to map law onto cybersecurity practice. I think the challenge in mapping law onto cybersecurity can roughly be categorized into 3 problems: scope, universality, and accessibility. Scope is a real challenge because there's such a broad scope of activities that are identified as cybersecurity. This leads to an enormous variety of legal issues that need to be taken into consideration at times. The other challenge with scope is that understanding law as applied to security problems can actually be pretty challenging, and I'll explain a bit more about that later on. Second challenge, universality. Or I suppose I should say lack of universality. You see, science and mathematics are essentially universal. The speed of light in a vacuum is the same in North America as it is in Africa, as it is in Asia. But laws and regulations are local. They differ from place to place. So it's difficult to teach law as a universal subject. But we know that security practitioners work in a global environment. And for that matter, students coming to universities arrive from multiple jurisdictions. So that naturally raises the question, what can be generalized? And in the law and regulation section of SciBoc, I spent a reasonable amount of time trying to abstract out principles that could be generalized in many jurisdictions at once. Finally, a non-trivial challenge, and that is accessibility. How do you make this subject matter, this legal and regulatory subject matter, accessible to students and practitioners who start without any foundational education in law or legal research, or for that matter, the humanities or literary criticism, or any number of other backgrounds that would prepare them better for grappling with law as a subject? So these are the challenges to try to overcome. Now, what I have next are a series of pedagogical challenges when presenting legal topics to cybersecurity students and practitioners. And here we're partly getting into this problem of accessibility. And I've got, I think, about 4 slides on this. The first is, I sometimes wonder, scientists and lawyers, are we two peoples separated by a common language? My favorite example of this is the word proof or prove. And when I first started teaching university students in cybersecurity about law, I would constantly get pushback from the students who came from particularly science, technology, engineering, and mathematics backgrounds. They'd say, well, how do you prove that? And I would answer, well, you get evidence. Yeah, but how do you prove things? And it took me a long time to realize that part of the disconnect is that, for example, if we look at the world of mathematics, to prove something means to establish as a logical necessity, undeniability, to establish truth beyond dispute, what some people call ground truth. And you can see an example of this here in a slide that I use in the SciBoc webinar that I mentioned, the Pythagorean theorem. This is logically provable. It is a truth beyond dispute. Compare that with law. In law, when we say we're going to prove something, we mean we're going to use permissible evidence in an effort to persuade a tribunal, a judge or a jury, of the correctness of a disputed issue. And here's the trick. When you're dealing with proving something in a court of law, you have to accept that some residual uncertainty is inevitable. There will always be some residual uncertainty, even if you have one of the best, most provable cases on the face of the planet. And here, the example, one of my favorite, from the film A Few Good Men with Tom Cruise. Colonel Jessup ordered the code red. That's great. You have proof of that? It doesn't matter what I believe. It only matters what I can prove. That's the kind of proof we're talking about. Or, to take a more recent quote from David Gerard's very entertaining book, Attack of the 50-Foot Blockchain, the purpose of law is not to achieve philosophical or mathematical truth, but to take a messy reality and achieve workable results that society can live with. I don't think I can put it any better than that. The next challenge we face is shifting the framework of analysis, shifting the framework from thinking about devices to thinking about persons. Let me give you an example. Someone makes this statement. They give a long lecture, and then they say, therefore, Bob can trust that Alice signed the file. Well, great. Okay, what does that actually mean? Now, coming from a computer scientist, I assume what they mean is that Bob has mathematically proven something about an action attributed to Alice. Although, let's hold up just a second. I know that what they really mean is not a human being called Bob. We're talking about 2 technological devices. What I like to call device Bob and device Alice. Maybe they're trusted computing modules, maybe they're bits of software. If we really abstract out, maybe it's just the pure mathematics of a cryptographic algorithm under analysis. But in the hands of someone like a computer scientist, this statement means device Bob has mathematically proven something about an action attributed to device Alice. Now, when a lawyer hears a claim, or when the system of law that we study tries to analyze a claim like Bob can trust that Alice signed the file, what we become interested in is trying to assess if a person named Bob, let's say person Bob is the person using device Bob, and person Alice is the person using device Alice. We want to assess if person Bob would succeed in a lawsuit against person Alice, and then there's a whole series of questions. What if something goes wrong with device Alice? What if the user interface on device Bob is so poorly designed that person Bob doesn't understand it? What if person Alice doesn't take appropriate care with the device Alice signing key? What if the trust certificate was misissued? What if someone named person Mallory somehow interferes? Anyway, the number of permutations that start to come up, because now we're talking about 4 points of analysis rather than 2. We took a very simple framework of analysis about device Bob and device Alice, and now we're stepping back and saying, well, forget for a moment about the devices. What about the responsibilities of the persons to one another? Yes, we'll need to dig into and forensically understand what the devices do and how the devices work and how the devices might have failed. But we also need to understand the relationship between the person and their device, and between the persons more broadly in a social setting. Oh, and it gets a bit more complicated, because we also need to think about the difference between natural persons and legal persons. So maybe whatever problem we're trying to analyze has to do with someone called person Charlie and what he did, and then we need to figure out his relationship, let's say it's an employee, of person Alice, a corporation. So now person Bob wants to sue person Alice, but first has to analyze if person Charlie did something awful and to whom does person Charlie owe a duty of care, etc., etc. So you can see the framework of analysis starts to get a bit more complicated. Another thing that I find happens routinely with the students who've come to me over many, many years from STEM subjects. I've really struggled with how to explain this one. And I think the best I can do is to say that I think there's a lot of work to be done for some students in reassessing their understanding of a systemic failure. Let me tell you what I mean by that. Let's start with a series of circumstances where an individual failure, or perhaps a couple of individual failures, are equivalent to, mean the same thing as systemic failure. And you'll recognize these pretty quickly. For example, a new bridge recently constructed collapses in relatively mild weather. That's the sort of thing a bridge is not supposed to do. So this bridge collapses. That is the equivalent of strong evidence that the bridge design has failed and should not be repeated. The single incident in this case demonstrates the failure of the system. Bringing it a little closer to home in cybersecurity, imagine that a serious flaw is discovered in a cryptographic primitive and published. Well, once again, this is equivalent to strong evidence that the cryptographic primitive has failed and should be deprecated. As a cryptographer friend of mine said to me a number of years ago, Rob, once the algorithm is broken, it's broken. That's it. You got to find something else. You learn a lesson from how the algorithm was broken, but you have to move on. Now that is what I would describe as a very absolutist frame of reference. Once it's broken, it's broken. Once the bridge collapses, there is no more bridge, and the design is flawed. We can't use it again. Now let's shift gears and look at some examples where individual failures are not the same thing as, or don't necessarily prove, systemic failure. And each of these examples will come up in law and policy. So the first one that I like to use as a teaching tool. Imagine, if you will, that 52% of car drivers in the United Kingdom go too fast. They exceed the speed limit when they're driving on 30-mile-per-hour signposted roads. 52%. And it turns out that 5% of car drivers exceed the speed limit on a 30-mile-per-hour road by more than 10 miles per hour. So 5% of car drivers are observed driving at more than 40 miles per hour in a 30-mile-per-hour zone. Now, reasonable people might differ about this, but I would suggest to you that this on its own is not the equivalent of strong evidence that speed limits are somehow a failed public policy and should be repealed. I don't know too many people who look at this circumstance and say, oh, well, clearly the solution is to get rid of speed limits because they're unenforceable. Far from it. Now, one of the reasons that people draw that conclusion, if you look at the asterisks here, if you look at the special qualifiers, and these are real statistics, by the way, you'll see that we're talking here about drivers in what are called free flow conditions, which is to say the only thing that slows the driver is their individual willingness to comply with the speed limit. So there's an open road. There's no speed bumps. There's no hugely congested traffic, things like that. So even in those circumstances, we find 48% strict compliance with a 30-mile-per-hour speed limit, and we find 95% compliance, at least if you define compliance as not going above 40. That's, by the way, is not a good thing to do. There's been a lot written about why the difference between 40 and 30 miles per hour. I don't want you to get that idea. My point here is that no one looks at this series of individual failures and says that of necessity that means there is a systemic failure and we must abandon speed limits as public policy. To give a bit more of an emotional example, some murders remain unsolved. We have laws against murder. Some murders remain unsolved. The bad person is not caught, or they're not successfully prosecuted. I would suggest to you that although this might be an example of injustice, it is not the same thing as strong evidence that prohibiting murder is a failed public policy. No one that I know of looks at this result and says, oh, clearly the result is that laws against murder don't work, they're unenforceable. Well, wait a minute, are they really? The fact that some people get away doesn't mean that the law is unenforceable, it just means that we have a problem of some degree. So now let's bring the same observation back into cybersecurity. There are some people who fail to take data protection rules as seriously as we would like them to. Once again, I submit to you that this is not the same thing as strong evidence that data protection law is failed public policy and should be repealed. Far from it. Data protection law has significantly influenced the actions of persons. And you see, that's really one of the significant differences when you start talking about law and public policy. It's about what people do, how to influence what people do, how to punish or reward what people do, to build a system of incentives and disincentives to try to alter the behavior and capture the values of a society. That, I submit to you, is a very different frame of reference for how do we need to think if we're going to build a bridge. Finally, I find that there are a lot of different techniques that you can experiment with to build a bridge, to reach out to students from a STEM background. So, for example, I use this slide in the SciBoc webinar that I produced, and it's possible to use, a function formula. Is this strictly correct mathematics? I don't know. But it stands for the proposition that if you're trying to assess legal risk, you have to look at more than just blindly look at just the rules. There's more that goes into it. You have to look at possible defenses, you have to look at what's at stake, and there's a number of other factors that you have to go through and think about in terms of assessing risk. The same kind of pseudo-mathematical presentation can perhaps be helpful in explaining how evidence folds into this problem, or about how rules of evidence work as a filter. Whatever. If it gets the message through, if it helps people to engage with the subject, it's worth a try. I find that Venn diagrams can be extremely helpful. So this Venn diagram, for example, is something that I created to help students focus on the multitude of definitions in the Trust Services Regulation, which of course is what succeeded the original electronic signature directive in Europe. And at the confluence of all four of these sets, we have what that regulation defines as a qualified electronic signature. The largest set is the definition of electronic signature. And so with this slide, I was trying to get students to focus on how the various definitions in the particular regulation married up with one another. Now, this is the sort of thing that people in law school and practicing lawyers kind of do in their head, but they don't necessarily think about it in the sense of a Venn diagram. And what I was trying to do, and I have to say this actually succeeded very well, was bringing students along from an engineering background or computer science background to help them see how these things fitted together. And finally, another slide that I used in the SciBoc webinar, one of my favorites, is trying to explain the difference between what is meant by personal data and what is meant by PII. So you can see here the largest set that I've created is personal data from European law, GDPR, and then there are a series of different and conflicting definitions of PII, two from technological standards, and then one from a blizzard of different US laws, and then this last very, very small set is what I've described as what we persuade ourselves to believe is correct after multiple committee meetings. So once again, the goal is to try to get students familiar with what is the appropriate frame of reference in terms of understanding regulatory responsibility in dealing with personal data, because I find that this subject particularly is a subject of continuing confusion within the cybersecurity practice. Now let's turn the corner to something a bit different. I want to point out something that should be obvious, but nonetheless, I might as well explain it in some detail. And this will be the bulk of the remainder of this talk. And that is, basically, legal taxonomy definitely was not devised for the convenience of cybersecurity educators or professional societies. Now, to help you understand this, I want to first walk you through a typical legal education so that you understand, where lawyers come from. The foundational subject matter for anyone who studies law as a discipline, you'll see that there's a large strip of know-how at the base, which sometimes isn't even talked about. It's kind of assumed. Some law schools have specific courses about these particular issues, but some just assume you'll pick it up as you go. Legal research methodology, just understanding how to assess what you're seeing in the literature, the nature and relative significance of sources of legal authority, because there's all sorts of stuff printed about the law, there's all sorts of stuff written about the law, some of it is very significant and some of it is borders on irrelevant, and it's very difficult sometimes for people to know which is which. The subject of legal hermeneutics, which is just a fancy way of saying how do you interpret laws that have been passed? How do you interpret laws and legal documents? It's not as straightforward as most people think. I've had a number of really fascinating discussions with engineers throughout the course of my career who have read a particular law or a statute or a regulation, and they thought they knew what it meant because they could trace what they felt was a very clear line of logic. And then I had to help them sort of like redefine and reassess their understanding because they weren't bringing the proper interpretive tools to the law. I mean, let me put it this way. A judge does not interpret law in the same way that a compiler interprets source code. Two different types of processor. There's also the problem of rhetoric, which is just how to persuade people of things in argumentation. Once you get past that base layer, you then get to the substance of law and legal education. And when I show you this foundation here of contract, tort, property, procedure, by which I mean criminal procedure, civil procedure, and the rules of evidence, criminal law and human rights law, this is more or less what most people, at least in English-speaking jurisdictions, would view as the foundational subject matter of a legal education, and it's been this way more or less since the late 1800s. I believe the person to credit for that is Christopher Columbus Langdell, the man who was the dean of Harvard Law School at that time. So this is more or less what people are required to study as foundational material to understand how law works and how to become a lawyer and how to interpret laws. When you move up from this foundation layer, you get to a layer of courses that I think of as courses about government concession and government regulation. So if we look at the law of corporations, or what in England we call companies law, this is the law about how corporations are formed, how they're governed, shareholder rights, the rights of members of boards of directors, liability of shareholders, or limited liability of shareholders. All that kind of razzmatazz you find in companies law. And companies are only given these special positions of insulating their investors from liability as a result of a government concession. Competition law, government intervention in the market to correct what economists sometimes call market failure. We're trying to avoid too much collection of power into the hands of individual persons. Intellectual property, a special government concession that's supposed to reward innovation, supposed to reward artistic endeavors, or in the case of trademark, supposed to protect investment in goodwill and good name. Environmental law, once again, government intervention, government regulation in the case of market failure to try to stamp down or reduce negative externalities from business operations. Employment law, another intervention that seeks to redress the imbalance of power between employer and employee. And finally, tax law, an intervention which seeks to fund government activities. So all of these layers of courses come after the foundation courses. Not every lawyer studies all of these subjects. As you move up this series of courses that I'm going to show to you, you'll find that most of the lawyers you meet, possibly all of them, will have studied everything at that bottom layer. But not everyone will have studied everything in the second layer. You start to specialize. You start to pick where you want to go. When I was a law student in Washington, D.C., my law school was very large. We had something like 500 or 600 courses in the list of courses that were possible to take. Not all of them were available all of the time. But what you knew is that all of us who were on the program for a JD degree, all of us had taken most of these courses in the bottom layer in our first year, and then you start to diversify and find your own path. And you need to think of it as a path. The path to everything on top leads through the courses on the bottom and the skills underneath those courses. The next layer, advanced topics, or what I think of as advanced topics. These aren't terms of art in laws or law school. These are just like ways that I've tried to explain it. So you get things like banking law and commercial law. Commercial law used to be an enormous topic, let's say 50 or 60 years ago, and it's kind of reduced a little bit over time because of the intervention of financial services, but that's a different story. Banking law, still a hot topic, and in cybersecurity sometimes a hot topic, particularly things like the Payment Services Directive 2. You get into advanced and deeper discussion of some subjects, like tort special subjects. You find specific regulatory regimes, which might be at layer 2 or might be at layer 3, data protection. Then these last three on layer 3 are a little bit interesting because they come back to haunt us again. Private international law, which is the rules that most people understand govern the question of how do we figure out whose law applies when people are entering into private relationships from different territories. And public international law, which is the body of law that regulates how states, how sovereign nations deal with each other. And finally, of course, international trade, which is theoretically, I suppose, a subset of public international law. Okay, so these are the kinds of courses that you would expect to see in many law schools, if not most. Almost all law schools, at least in common law jurisdictions in particular, and many civil law jurisdictions, will teach a version of those foundation courses. Many or most of them will teach a lot of these courses in the middle layer. Some of them will focus on different things in this third layer. Well, now we get to the real trick. Law as applied to special types of business process, or law as applied and special interventions and regulatory regimes that are a lot more new or a lot more fresh. And what you see here, so for example, most of my career has been spent in this area that you see at the top marked IT law and cyber law. And really what that is a process of taking contract subject matter, tort subject matter, procedure, criminal rights, human rights, competition law, intellectual property, law of corporations, private international law, data protection, and applying it to information technology or applying it online. You see, computer crime. Now, there's a slight difference. We get things like new systems of criminal law, like crimes against information systems, the Computer Misuse Act 1990, or the 1980s legislation in the United States about computer fraud and abuse, come into that. Also coming into computer crime is, let's go back to our foundation courses like criminal law and criminal procedure and human rights law and start talking about using the internet as an instrumentality of crime. So online fraud, things like that. You'll find things like media law. How do all these subjects apply when you're dealing with media companies, with media transactions, with performing rights? Financial services regulations, the same. Corporate finance, similarly. You just draw a path through a lot of these foundational courses, and then you do a lot more study as applied. Energy regulation. I mean, way out on the side here, for a little bit of fun, I've mentioned horse race law. Now, the only reason I mention it, it's not going to come up anywhere in cybersecurity, anywhere else in the rest of this talk. But I mention it because I remember reading an article in the ABA Journal many years ago about how practitioners were coming together to try to define how the practice of law should work for people who represent owners of racehorses or owners of horse tracks. So, it might be a small community of practitioners, but nonetheless, they're focused on this problem of law as applied to a particular business process. Okay, I've taken you through the journey that a lot of people follow in order to understand how law works and to become lawyers. So in order to make this relevant to cybersecurity, let me show you how some relatively straightforward cybersecurity questions lead to what I can only describe as kind of complicated legal answers. Or which of these subjects do you need to be familiar with in order to answer them? And I've got 4 examples. The first, how do we convict persons for hacking crimes, or what in Sybok I've referred to as crimes against information systems? Well, to answer this question, how do we convict the hacker? We need to touch on a series of different laws and subjects. We're going to need to think about criminal procedure and evidence, particularly because this limits forensic investigation technique. If you don't follow the rules correctly, you might not be able to introduce evidence in court. If you can't introduce evidence in court, you can't prove your case. You can't prove your case, you go nowhere. There's basic criminal law folds into this. There are some elements of crime, for example, where you need to prove the intent of the accused, and that comes from basic criminal law. Basic human rights law, particularly for investigators who are working for and on behalf of the state, police investigators, security service investigators. They have to be cognizant that their freedom of maneuver is limited by human rights law because it's meant to protect the citizens and residents of the state where they work. You then need to get into the law as applied category to look at specifics of computer crime. For example, in the United Kingdom, the Computer Misuse Act 1990. And then finally, particularly if you work as a police officer or another state official, you might need to start to get familiar with public international law because you're going to need to worry about extradition, the problem of dual criminality in extradition treaties, and mutual assistance treaties in an effort to try to investigate across borders. Now notice that the first of these, criminal procedure and evidence, is something that I've flagged as a topic that's difficult to generalize on a multinational basis. And that's because most procedural rules, court procedures, which might be described as criminal procedure, civil procedure, and rules of evidence, there are some common threads, but it's my contention that they're really very heterogeneous. They're very parochial. Courts tend to make up their own rules on their own basis, and they don't necessarily take a lot of inspiration from one another. So it can be very difficult, I think, to abstract a subject like criminal procedure or evidence rules out to a multinational student audience, and I think it would be difficult to try to pull that focus on that in terms of a credentialing scheme. Now, if we turn the corner Instead of hacking, what if we're talking about how do we convict persons for distribution of online pornography? Well, you'll notice that there aren't that many changes to the list of things we need to be concerned about. The only significant change here is this next to last bullet point, and that is we now need to be familiar with specific laws concerning criminal illicit content. How do we define it? Now, when you start talking about criminality, where the content of a message is the definition of criminality, that also triggers this problem of becoming difficult to generalize on a multinational basis. I mean, let's look at the United States, for example, as a case study. In the United States, the definition of pornography, or let's say the dividing line between what constitutes protected free speech under the First Amendment and what can be criminalized as pornography, the Supreme Court of the United States basically threw up its hands decades ago and gave up on this. And they said, well, the way we're going to assess it is by reference to local community standards, which means that in 50 states plus the District of Columbia, the definition of what can or cannot be made illegal has to be measured by local community standards. Similarly, when you get to a relatively homogeneous territory like the European Union in terms of its value system and how it's trying to pull together, you still find a wide degree of disparity between different countries in the Union on this question. And now when we broaden focus even further, let's say we're no longer talking about online pornography, let's instead talk about more generally the problem of illicit content. There are places, many countries in the world, where the definition of content that is illicit would absolutely be recognized as protected free speech and human rights in another country. And if you're in a university and you're taking students from a number of different countries around the world, you may well be facing a group of people who are going back to work in a country where their definition of criminal illicit content is different from yours. That creates a challenge when you're trying to construct a syllabus that has value for practitioners in many jurisdictions. Third question: how do we assess the liability of any of these people? A fleet operator, an importer, a manufacturer, a supply chain partner, or a post-market service provider? When a cybersecurity failure leads to an autonomous vehicle incident and personal injury. In other words, something goes badly wrong on the autonomous vehicle security, supply chain, and as a result, the hacker is able to throw somebody into a wall or kill someone with a car. Now, the question, how do we assess the liability of these various people, I submit to you, is roughly correlated with how can we predict commercial incentives to invest in security. Because everyone involved in the supply chain for these types of solutions are very well aware of their legal responsibilities and how liability might arise. And many of them understand that they can't get away from liability simply by saying we tried really hard or we weren't negligent. That's often not enough. But to answer this question, we're going to need to touch on a number of subject areas: basic tort law, the law of negligence, damages, vicarious liability. We're going to have to get into a slightly advanced subject: product liability related to software failure. We're going to have to talk about contract law, limitations of liability, exclusions of liability, and the enforceability of limitations and exclusions of liability, and the calculation of damages. And we're also going to have to get into private international law, because these cars aren't all going to be manufactured and sold by a supply chain that's all within one country. Supply chain materials and supply chain services are going to cross borders, and as soon as they do, you immediately trigger a concern about how do we analyze this problem using private international law of both contract and tort. Finally, one of possibly the most complicated problem that I've found in teaching: how do we assess the liability of a certificate issuer when the third party relying on that certificate lives in a different country? So in this chart, for example, I've hypothesized that a certificate authority, registration authority, and certificate issuer, which I assume for the purposes of this exercise are all the same person. I know they're very often different, but let's try to simplify for purposes of analysis. So the certificate issuer is in country A. Their customer the signatory, has registered a certificate for a public key in country A, that signatory uses their secret key, which corresponds to the public key, to sign a document and transmit the document to a third party relying in another country. The third party relying is clearly relying upon the certificate issued by the certificate issuer in country A. And the question becomes, what will be the nature of the liability of certificate issuer to this third party in another country? Now, to answer this question, we need to have some basic understanding, some basic facility with tort law, the law of negligence, understanding the concept of damages for economic harm. We need to look at a couple of slightly advanced subjects, liability for defective information and negligent misrepresentation. We also need to understand a bit about contract law, the nature of formation of contracts, privity of contract for people living in common law jurisdiction, limitations of liability, enforceability of limitations, damages, requirements of form, if any. We're also going to get into a discussion of companies law and the problem of agency. And finally, because we're crossing a border, we're looking at private international law for both contract and tort. And if you want to know why certificate issuance businesses did not become like the wildly successful business model of the 1990s that everyone thought they were going to be, what you're looking at right here is one of the most significant reasons. Even if over here in country A, let's call it the European Union, we persuade lawmakers to give us a very generous, legally grounded limitation of liability in public law, if the third party relying lives outside the European Union, we might not be able to rely upon that statutory limitation at all, because the third party relying might be grounding a tort claim in the law of their jurisdiction, which means that the electronic signature directive has no application to the dispute. At least that's the risk. Now that we've gone through these examples, let me give you, and this is the last part of the talk, let me give you some ideas about how to map legal subject matter onto cybersecurity degree programs and professional qualifications. I've called this a starting place for discussion. And as you'll see, what I want to do is walk you through a number of different types of degree program, a number of different types of professional qualification, even if they're all generally viewed as cybersecurity. There are 5 of them. Here's the first. I think this will be the one that is most familiar to many people who've worked in cybersecurity for a long time. And that is, what if the cybersecurity professional we're talking about is someone who's engaged in investigation and forensics? Investigation of materials on IT systems and IT computer forensics. Okay, basic principles. On all of these, you're going to see a focused spotlight on on the bottom layer, legal research methodology, nature and significance of legal authority, hermeneutics, all that kind of stuff. That's not going to change. But as we look up the ladder, foundation courses through government concession, advanced topics, and as applied, the forensic investigator is going to be very, very focused on rules of procedure, criminal procedure, and rules of evidence in the place where they are going to be presenting their evidence. Might not be where they live. Their framework for focus needs to be, where is the court where I'm going to have to introduce this evidence? That's where you need to be concerned about your criminal procedure and your rules of evidence. They're going to want to be pretty familiar with the basics of criminal law, and since many of these people will be working for a police department or perhaps former police officers, they will undoubtedly have become familiar with that as part of their training. The flip side of that, they need to also be familiar with human rights law because, once again, they need to know the limits of how far they can intrude. They might get a little smattering of employment law, particularly if they're working in as a private sector investigator, to know what to look for in terms of like violations of employment responsibilities. And they might need to know a little bit about intellectual property. For the state investigators who are involved in investigating those very special circumstances where intellectual property infringement constitutes a crime, which is to say, wholesale ripping off of, large bodies of protected works, they're going to want to know those specific rules. And even the private sector investigators will at least want to have a passing familiarity with IP rules just to make sure they stay on the right side of them. Similarly, data protection. if you're going to investigate problems as an outgrowth of human rights. I mean, the path to data protection these days goes through human rights, not through anything else. So they'll need to be familiar with, once again, how far can we go? What kinds of things do we need to be familiar with? For state investigators, they'll need to be familiar with the area of public international law that talks about things like extradition and mutual legal assistance. And finally, they'll end up being specialists on computer crime. And notice that the focus up in computer crime is way over in the direction of primarily, if not exclusively, computer crime, a little touch of cyber law, maybe even a little skosh of media law, but not much to do with what lawyers in the UK would refer to as IT law as such. These are people who don't need to worry about computer contracts or about copyright and software, but they do need to be worried about things like what are the rules about not hacking into systems, and also how do we apply the law on old laws on things like fraud and bank fraud in using computers as an instrumentality. Well, that's fine. This picture is the beginning of a discussion on how to put a curriculum together, on how to put a qualification together when the cybersecurity professional is going to be involved in investigation and forensics. But what if they're doing penetration testing? What if that's their focus? Well, at this point, the focus shifts. There's less need to be concerned about rules of procedure and rules of evidence. There's less need to be concerned about the foundations of criminal law, or for that matter, of human rights law. It doesn't disappear entirely, but there's less need for it. There's still a residual need to worry about employment law, particularly because the penetration tester will need to be concerned about not intruding too deeply on the human rights of the people who might be at the other end of the testing. But now, notice that we start to pick up some interest in the law of contract and the law of tort, in part because a penetration tester is going to need to have an understanding of how to structure an engagement with their client, and they're also, under the law of tort, they're going to need to understand to whom do they owe a duty of care. And it's not just their client. A duty of care can be owed to third parties they know, third parties they've never met. You can end up with negligence liability to somebody you've never met. The only thing that matters is whether they are a foreseeable victim of what you've done badly. Similarly, intellectual property, data protection as before, once again, computer crime. One of the main things that penetration testers need to make sure of is that they don't themselves violate computer intrusion laws as a part of delivering their services, and that's part of what the contract piece is about. Third use case. What about security professionals who want to become involved primarily with security product development? Once again, we see a different picture. Now, knowledge of criminal law and human rights law has reduced to a very small amount, depending on the nature of products that you're developing. Rules of procedure and evidence, it might be important, it might not be, again, depending on the product line. If you're developing products for forensic investigators, then yes, you're probably closer to the forensic investigator path than you are to this. But notice that now intellectual property has become a major area of focus. When I was writing SciBoc, I was at an industry dinner seated across from somebody I've known for a number of years, and I was telling him about the writing process, about trying to explain law that applies to cybersecurity. And he said to me, he says, "Oh, well then I'm assuming you'll have to talk about intellectual property because it's the only part of law that really matters." And that kind of surprised me. But what I said to him was, I said, I understand how you reach that conclusion because you have spent your career as an inventor of security products. So for you, it's been critical for you to understand when you can develop something that can be subject of a patent application, because you've got a lot of them. So for this person on this track, they've got other subjects they're worried about. Now, they're going to be worried about tort, the law of negligence, and some special subjects, perhaps, like negligence or liability resulting from software failures. Because if they're going to put a product into the market, they might need to be concerned about, what potential exposure they have downstream. They might be concerned about banking and commercial law, particularly if their product line is going to facilitate electronic payments. Same with financial services regulation. I mentioned medical regulation suddenly comes out of nowhere because maybe they're developing a product that they want to sell into the medical market, and they discover, like so many verticals these days, there is now specific industry regulation that talks about security requirements. So to the extent that someone wants to develop products for those verticals, they need to start to become familiar with the regulations that are now specifically designed for those folks. And once again, a smattering of IT law, computer crime, and cyber law. Fourth use case. What about someone who wants to become a diplomat, who wants to study international relations, who wants to study the nature of will there be cyber war and what will it look like? People who want to work in national defense for the Ministry of Defense or the Department of Defense or whatever state defense agency you want to work for. Notice now that the focus has really skewed very, very heavily towards public international law. And once you get there, you're really talking about getting to grips with the kinds of stuff talked about in the Talon Manual 2.0 on the application of international law to cyber operations. This is the foundational subject matter that is influencing many sovereign states around the world in the conduct of both defensive and offensive cyber operations. It's a hot topic of discussion for anyone who wants to work in that environment, either behind the scenes in uniform behind a screen or sort of in, let's say, front of house at international conventions talking about what should we do in order to keep the peace. Similarly, there'll still be some interest possibly in banking law because that comes up a lot in international negotiation. International trade suddenly enters into the discussion. Private international law a little bit just to be familiar with it, possibly a little bit of concern with tort to understand the concepts of negligence liability, but not necessarily drilling down deeply. And suddenly other things start to become maybe possible, like energy regulation. Why energy regulation? Well, once again, it's a vertical sector that's starting to get its own body of regulations that deal with cybersecurity and its critical national infrastructure. So someone working in international relations might need to become familiar with the regulatory regime that applies to cybersecurity in critical national infrastructure. Last use case, last example. What about a cybersecurity professional who wants to move more generally into what I call enterprise risk management? Now, this could be almost anything, really. But here, what I have in mind is the kind of person who wants to proceed through some type of a career path which might ultimately lead to being a chief information security officer or something like that. Well, now the focus is spread all over the board. We have all kinds of things that have become important. Contract law, tort law, the law of negligence. Notice that the law of corporations, companies law, has come into it. Because folks like this who are working in the private sector are constantly confronted and are constrained by and need to work to the needs of corporate governance. They're dealing with boards of directors and supervisory boards and management chains. And so they need at some point to become at least basically familiar with what a corporation is and how it operates. They're also going to be interested in private international law primarily because everything that we do with the internet is going to touch and concern multiple jurisdictions at once. Private international law only helps you after you've studied a lot of these other topics, because private international law is that body of law that helps you figure out, well, is it the law of England, or will it be the law of France, or the law of Indonesia, or the law of California, or something else that applies to this particular aspect of a dispute. It's helpful to know that. Data protection, obviously in the frame. Employment law, of course. Notice that the focus on procedure and evidence is very small, very light. Notice that the focus on criminal law is almost non-existent. If you look up in the layer of law as applied, notice that the region of focus has shifted significantly away from computer crime and into the area that is commonly called in England cyber law or IT law. Now, why is that? If you talk to most people who do enterprise risk management, they know a terrible truth, and that is they are not engaged in the process of catching computer criminals and putting them in jail. Worse, they know that damage caused by a computer criminal is not going to be paid for by a computer criminal. They know that damage that a computer criminal precipitates will eventually result in some series of payments between a whole bunch of people, none of whom committed a crime. but some of whom will be responsible to each other by operation of things like negligence law or because they have to answer a problem from a regulator. So, how do we summarize all of this? Bringing law to cybersecurity education and qualifications. Well, a few slides. First of all, I hope it has become easier to see that there is no one-size-fits-all solution to this question. Whoever you are, degree program manager, someone looking after professional qualifications, or a student trying to figure out how to develop your career, select topics that are appropriate to the subject matter you're focused on. We need to accept that within cybersecurity, people with different roles have different needs. There are some practitioners out there who will not need a deep understanding of whatever it is, legal topic X, whereas other practitioners will be unable to do their job without it. And the trick is to identify which is which. In terms of dealing with educational curricula, what about relying on existing education programs that are designed for lawyers or law students? Well, now here you hit a problem, and that is those programs are really not focused on the needs of cybersecurity education and training. They're not designed for the sorts of people we normally think of as cybersecurity practitioners. There might be a few exceptions out there, but I haven't really seen them yet. The foundation subjects are far too detailed. They take too long to go through. And let's face it, if you did those, you would be in law school. And that's not what we're looking for. Well, what about just jumping to the top of that tree? What about doing the advanced and as-applied subject matter? Well, the way that those courses are taught in law schools is, once again, they presuppose that the students coming to the class have already taken the foundational elements. So there's very often a mismatch of expectation, and I've informally heard some reports where cybersecurity students have been thrown into an environment like this and have really struggled to get through it, which is a nice way of saying they mostly wipe out. The approach that I've taken over the years is a hybrid approach. And this takes a little time to craft. It takes time to design and implement. And that is, you lead cybersecurity students and trainees, whoever they are, through relevant elements. You look for and you pick out a few key elements of foundational materials in order to give them context. And then you present them with advanced subjects as appropriate. So, for example, in my module, I usually start with just a basic grounding in just legal topics generally. Just, what is law generally? And then we move into a specific subject matter like contracts for a few hours. And then we spend a number of hours on tort, negligence, duty of care, those kinds of things, defenses to negligence, because they come up again and again later on. And it's only after we've done a number of topics like that, much later in the course, that I come back with a topic like private international law, because it's almost impossible to discuss that without the foundational material. And then I only get to liability for trust services after we've discussed all of the foundational material and private international law, because the discussion doesn't make sense until then. In any event, whoever you are, whatever you're focusing on, I urge you to take a careful look at what you're trying to accomplish with your degree, what you're trying to accomplish with your professional qualification system, what you're trying to accomplish with your career, and make decisions accordingly about what should or should not be on your curriculum. If you have questions, I hope that you'll contact me. Please reach out, open up a discussion. If you like this video and you're watching it on a platform that allows you to give a thumbs up, then please give it a thumbs up. Feel free to make a comment. If you have other comments, obviously you can write to me. I'll be happy to hear from you.